The broadcast is now starting. All attendees are in listen-only mode.
Well, good afternoon, ladies and gentlemen. Apologies for the late start. We've had a couple of technical problems at this end, but I'm pleased to say we've got those resolved. And so I can now formally welcome you to the latest in our People Hour series. And this one is entitled Not #MeToo, Sexual Harassment Claims in the Workplace. My name is Simon Horsfield, and it's my pleasure to be presenting this particular topic to you. My contact details are there. If there's any follow-up questions following on from this seminar, please do feel free to get in touch with me, or of course your usual gunnercooke advisor. So, just before we start the presentation, a couple of housekeeping points. We have this in the diary until 1 o'clock. I think there's ample time to get through the presentation itself within that time. I'm not proposing to take questions as we go, but we do those questions. And the easiest way for me to do this would be then to get to the end of the presentation and run through any questions that we have. There's someone on the line who might need to just put their phone on mute. I'm getting quite a bit of feedback there. So if whoever's not on mute could put themselves on mute, that would be helpful. So, to start then with what we're going to be covering in today's webinar. Firstly, we're going to be looking at what is and what isn't, importantly, sexual harassment. So a real closer look at the definition, something that we're all going to be familiar with, but with benefit from.
It's watching. Can you hear it? Yeah, what?
We're then going to look at how to respond to sexual harassment, including historic allegations. We will think about the potential for some overlap here with whistleblowing, another area of risk when we're dealing with sexual harassment. And then we will conclude by looking at ways that we can consider managing any resulting claims that are brought in an employment tribunal arising out of alleged sexual harassment. So, to begin with, what is sexual harassment? Sexual harassment occurs, according to the definition in the Equality Act, where a person engages in unwanted conduct of a sexual nature. And, importantly, where that conduct has the purpose or effect of either violating that other person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for that person. And we're going to look a little bit more closely at what amounts to unwanted conduct and what constitutes a purpose or effect in a moment. But before we do that, probably worth just reminding ourselves what the Equality and Human Rights Commission say about this issue in their Code of Practice. And they say that unwanted conduct can consist of verbal, non-verbal, or physical conduct of a sexual nature. And the conduct of a sexual nature includes unwelcome sexual advances, touching, forms of sexual assault, sexual jokes, displaying pornographic material, or sending emails with material of a sexual nature. And as I say, most of this is going to be familiar because this is the kind of language that, generally speaking, has been cut and pasted into anti-harassment policies up and down the country. But let's just pause and think what we mean by this term unwanted conduct. Now, in some cases, it's going to be very obvious what we mean because the victim will have made it very clear to the perpetrator that what they are doing needs to stop. And if that person continues doing that action, then that will clearly fall within the definition of unwanted conduct. But that, of course, begs the question whether conduct can be unwanted if the victim hasn't done anything to stop it. And there have been a number of cases that have looked at this, and those cases have concluded that the victim doesn't need to make it clear that the perpetrator's conduct is unwanted for it to amount to harassment. The other point to just think about here is when we see phrases like unwanted conduct, we tend to think that that requires the incident to have happened on more than one occasion. But again, there have been cases that have confirmed that a one-off incident can amount to harassment. The one that immediately springs to mind, in situ cleaning and heads. Young male employee greets his older, I think she was in her 50s, but it doesn't matter, older female manager with the affectionate words, "Hiya, big tits." And that was just a one-off event, but it was deemed to be sufficiently serious to amount to sexual harassment. And one of the themes that's emerged from the case is looking at this issue of what amounts to unwanted conduct is almost a presumption that some conduct is sufficiently serious that it just has to be presumed to be unwanted unless it can be proved otherwise. And that requirement to prove otherwise will, of course, require close analysis of the victim's behaviour, the extent to which they played along with things, the extent to which they were demonstrated themselves not to be particularly sensitive to these kind of issues. A good example of a case looking at the area of unwanted conduct is this Reed and Stedman case, Employment Appeal Tribunal. And here we have an individual who alleged that there had been numerous incidents of sexual harassment. The employer's defence was that the individual never confronted her harasser and in fact only complained about his conduct on one occasion, the last occasion. And the EAT confirmed that the failure simply to confront the harasser did not mean that the conduct was wanted. So clearly there's a requirement to look at things from the viewpoint of the victim, and that's something that we'll come on to in a moment. Another case on this area of unwanted conduct, the fantastically named Munchkin's Restaurant and Karmazine. Here we have a young female worker in a restaurant alleging she'd been harassed. I think she was 22, and I think the owner of the business, who was the alleged harasser, was 71 years old. And this harassment apparently occurred over a long period, and it involved unsavoury things like repeated attempts on the part of the owner to discuss this worker's sex life with her and that kind of conduct. Now, it was accepted that this particular individual did engage with the owner of the business in talk of a sexual nature, and on occasions, in fact, she would initiate those conversations. But significantly, the tribunal was very sympathetic towards this particular individual and found that her conduct was actually a tactic that she used to divert attention away from herself and her own sex life. So actually the fact that she engaged in this kind of talk didn't defeat her argument that she had been sexually harassed and that this conduct was unwanted. And there's a really telling comment by the appeal tribunal, which is that this individual was just putting up with this conduct, and putting up with it isn't the same as making it welcome. Now, as I've said at the bottom of the slide, it's possibly relevant here that we had such a huge age discrepancy. We had an individual who was only 22 being harassed by the owner of the business. She was also a vulnerable migrant worker, and so I think that will have created a degree of sympathy there for her. But clearly, this is a very important case in terms of making us appreciate just how wide this definition of unwanted conduct can be interpreted. Now, as well as the conduct being unwanted, it has to have the purpose or effect of affecting the individual's dignity at work and so on. And where somebody has the purpose of affecting somebody's dignity at work, then clearly that definition will be satisfied, but it's not easy to prove what somebody's purpose is. What was their motive or intention behind the way that they behaved? And that's why the definition goes wider than that and looks at the effect that's been caused. And what this essentially means is that the alleged perpetrator's motive is irrelevant. Even where they didn't intend to harass the victim, then the effect of their conduct on the victim still has to be considered. And what this therefore means is that we move into a subjective approach. What did that particular victim feel? How was that person made to feel as a result of the other person's conduct? That subjective test is reined in slightly, though, by virtue of section 26(4) of the Equality Act, which does impart a degree of objectivity, because conduct will only be considered as having the necessary effect on the victim where it's reasonable for the conduct to have that effect. So in other words, a hypersensitive claimant may well not succeed if it wasn't reasonable for the individual to feel intimidated, degraded, demeaned in the workplace, then that won't necessarily make out a harassment claim. So one of the issues that keeps cropping up for me at the moment in terms of advice that I'm being asked to give to clients is, where do you draw the line in terms of establishing what constitutes sexual harassment? And obviously this issue is very much in the public eye at the moment with the hashtag #MeToo campaign, and in some cases the stories that are being reported are of the most extreme kinds of harassment and indeed sexual assault. And with those, clearly no issues in terms of understanding where the line is drawn. Where it becomes more difficult, I think, is in those areas that I've identified there, things like consensual banter, flirting in the workplace, or people who are just naturally tactile. And when does that behaviour cross the line into from acceptable to unacceptable, and when does it become sexual harassment? And as I've suggested there, I think it is a case of viewing that behaviour in the round, looking at all the circumstances. Context is very important here. What was the working environment like, and very significantly, what was the relationship of the two individuals involved? And by that I mean, where do they sit in the organisational chart? Because it seems to me that a lot of the cases that we see reported involve a manager allegedly harassing a subordinate, and clearly that requires a different kind of assessment compared with allegations of harassment between peers. I'm not saying that one is more acceptable than the other, I'm just saying that a different test has to be applied. Other factors that need to be considered is the extent to which the victim has done something to discourage the conduct, but as we know from the cases we've looked at, that isn't the be-all and end-all. We need to think about what the victim's perception is and consider whether their response is a reasonable one if they feel harassed. But applying that in the context of consensual banter, flirting, and being tactile, to me, I think the key question to ask in those circumstances is whether the conduct is of a sexual nature. And if consensual banter is spilling over into banter of a sexual nature, then clearly it is capable of amounting to harassment. And to my view, where that is happening let's take the example of a female worker feeling harassed by virtue of banter in the workplace of a sexual nature. If that individual is outnumbered, so that there are more males than females in the workplace, then it will be much easier for that individual, it seems to me, to say that she was just putting up with it and going along with it, compared with an environment where the gender split is the other way round, and that conduct is still going on. In the case of flirting, I think for me, again, it's that difference between low-level flirting, where someone is looking to establish whether there is a potential interest and looking to see whether a relationship might develop, compared with flirting of a sexual nature. Again, where you draw the line is very difficult to define, but it seems to me that it would be, apart from where there's a ban on workplace relationships, it would be too draconian to say that it isn't acceptable to proposition someone in the workplace and ask them out on a date, but clearly crossing the boundaries and engaging in physical touching and sexual innuendo starts to take that flirting into unlawful harassment, as far as I'm concerned. Being tactile, there's another one, very topical in view of the Michael Fallon touching the knee repeatedly of the journalist Julia Hartley-Brewer. Again, you have to question whether the tactile behaviour is of a sexual nature. It seems to me that is the clear distinction that has to be made. As I've said already, if the tactile behaviour isn't of a sexual nature, then it still could amount to sex harassment. And touching the knee, again, it would have to be taken in view of the context. And interestingly, I note that Julia Hartley-Brewer herself didn't feel harassed by that conduct, but that's not to say that another individual wouldn't feel very differently, particularly if it was from a senior person engaging in that behaviour towards one of their subordinates in a way that the individual felt trapped and unable to do anything about it. So no clear answers, I'm afraid, in terms of where to draw the line. Common sense approach has to apply, and it requires us to look at all of the circumstances. So how do we respond if we are faced with allegations of sexual harassment? It seems to me that often in these situations, the complainant will seek to raise their complaint informally. They will either report it or mention it to a colleague who feels compelled to then raise it with HR, or they will come to HR themselves just to make HR aware that this behaviour is going on, but they haven't particularly thought through how to deal with it. In those circumstances, my suggested approach is that you refer that individual to your own policy, preferably anti-harassment and bullying policy, but if not, certainly a grievance procedure, and discuss with them whether they feel able to confront the alleged harasser themselves and resolve the matter informally that way by making it clear that the conduct is unwelcome. And it may be that you offer to support them in that discussion, or indeed that you act as an intermediary and speak to the alleged harasser informally on their behalf. If you think that the conduct warrants it, then you may well try to encourage the individual to raise a formal complaint under your procedure so that you can then embark on a formal investigation. What I don't think we can do, though, and we need to be very careful about, where somebody wants to raise something informally, is go around and ask questions of the team where the alleged harasser works, saying, we've heard about a complaint against John Smith. Have you seen any inappropriate behaviour? I think we have to recognise that John Smith has rights in this situation as well, and that unless and until the complaint is raised formally, we have to be very careful not to destroy trust and confidence in the relationship that we have with the individual who is the alleged harasser. So for me, I think in that situation where the individual doesn't want to progress matters formally, the best we can do is address the issue on a completely anonymous basis. Depending on the way your business is structured, it might be addressing it with the whole business. You might be able to drill it down into a particular division or team, and just remind them about what constitutes acceptable behaviours, what constitutes harassment, and how seriously those matters will be dealt with. Now, if a formal complaint is raised, then clearly the first thing to do is ensure that you are following your own policy and that you are being seen to take that complaint seriously. I think we then need to consider whether to suspend the alleged harasser. I think in many cases that I've dealt with, that has happened, although of course recently there's been a case suggesting that suspending somebody should be a measure of last resort. So query whether we should only be suspending where we think that there is the risk of further damage to the victim, or where the investigation might be compromised. And I would suggest that that's a good rule of thumb. If we are concerned about further harassment taking place, then we could consider whether or not we can separate the individuals and have them working in a different workplace or workspace. And if that's not possible, then we could think about putting in place some ground rules for the duration of the investigation in terms of level of interaction and so on. Now, clearly, we want to be conducting a thorough investigation, and we need to think about who should investigate. To my mind, unless they've been specifically trained for this purpose, sexual harassment allegations aren't really the sort of things that I would expect line managers to be expected to investigate, because they require a degree of sensitivity and a level of approach that I think is beyond the ordinary line manager, shall we say. So you may well want to keep these kind of investigations within HR, or you may even consider appointing an external expert to lead the investigation, depending on the seriousness and the level of people involved and so on. I think it's important, though, that we are seen to be approaching these kind of investigations with an open mind, and that we're pursuing all lines of inquiry. I think this is different from unfair dismissal territory, where we might expect that a range of reasonable responses test applies to the investigation that we carry out. Here, I think a tribunal is entitled to say, you should have done this, you should have followed up on that point. So we need to be much more thorough in the way that we go about the investigation. Perhaps the best way of illustrating how you should respond is to look at a really good example of where somebody didn't respond particularly well. And here I'm going to single out Britannia Hotels because of the reported case of Southern and Britannia Hotels, which is a tribunal case. So here we have another vulnerable claimant, so 22-year-old migrant who actually had a history of mental health issues, employed as a waitress on a 0 hours contract, allegedly harassed by her manager. And according to Ms. Southern, The harassment took the form of inappropriate touching of her bottom, kissing her neck, inappropriate comments about her sex life. On one occasion, the manager stood behind her, made a grinding movement simulating intercourse. So pretty unpleasant stuff. And she complained about this behaviour to the hotel manager, Mr. Whittaker, who undertook a bit of an investigation. There was a witness to some of the events, but Whittaker only spent 10 minutes interviewing her. She corroborated some of the stuff. She said she had seen the manager touching Southern's bottom and trying to kiss her neck and so on. But the manager vehemently denied the conduct. So Whittaker concluded that there were certain mannerisms and behaviours of the manager that were inappropriate, but he didn't really expand on this, and he failed to take any action against the manager other than just to speak to him and say, look, pull your socks up and have a think about how you conduct yourselves around this person in future. So on the back of this, Miss Southern lodged a tribunal claim, and she was in the process of going through that claim when an HR manager, Miss Burt, was appointed by Britannia Hotels to reinvestigate and try and tidy this mess up. And Miss Burt did try to do a bit more of an investigation, and she spoke to the same witness who had previously said she'd observed some of the conduct. And this time the witness kind of was a lot less certain and a lot more evasive in what she was saying, and just failed really to corroborate Miss Southern's version of events. But Miss Burt didn't look back at the previous statement to see what she'd said previously, and didn't therefore challenge any of the inconsistency in the evidence. She just jumped to the conclusion that there was no evidence of harassment. She took the manager's word for it that it wasn't happening. She said maybe there was a bit of neck kissing, but this was encouraged by Miss Southern because that's what the manager had said. And so she rejected the grievance, or concluded that there was no harassment. Again, Miss Southern appealed. The appeal went to a more senior manager who dismissed the appeal. And then the matter came to an employment tribunal. And the tribunal concluded that Miss Southern had been harassed. Interestingly, the manager was a lot less vehement in his denials when he was on the witness stand. And it appeared to the tribunal, they made a note of this in their judgment, that he was reluctant to lie under oath, and that was why he was being so evasive. And of course, that's just a useful reminder for us that however strong we think our case is, it can always fall apart in tribunal. On balance, and of course tribunal works on the balance of probabilities, they concluded that the conduct complained of had taken place, all of it, that it was unwanted, and that it was reasonable for Miss Southern to conclude that her dignity had been violated by this conduct. Now, what the tribunal went on to say is that actually Britannia had been pretty woeful in the way that they had investigated this. They'd had 3 opportunities to look at this properly, but they'd failed to explore matters fully. They were critical of the fact that Britannia had failed to suspend the manager. I'm not convinced that that's fatal in this case, but it was something that they pointed to, and I think it was something that contributed to, as we'll come on to, the injured feelings that Miss Southern sustained. They didn't follow up on the corroboratory evidence. In other words, they didn't pursue every line of inquiry. They didn't discipline the manager. And they dismissed the grievance for the flimsiest of reasons, and particularly failing to explore that witness issue fully. And as a result, Miss Southern was awarded injury to feelings of a compensation of £19,500, and the tribunal commented that it wasn't the worst type of harassment that you can imagine, but they did increase the award because Miss Southern was a vulnerable victim. And they were particularly impressed or influenced by the fact that Miss Southern was on a 0 hours contract. So she was dependent on this manager to make work available for her. And she was in that sense trapped. And this made the situation all the worse for her. Now, it seems to me that we can be quite critical of Britannia, and we can say, gosh, It wasn't that outrageous the way that they conducted that investigation. But actually, the challenge I would put, and I would put it to myself and to those of you who are listening, isn't that a way that many of us are conditioned to think? We don't like to make concessions. We like to find the kind of weasel wording that Mr. Whittaker said when there was a bit of inappropriate conduct, but it wasn't of a sexual nature, because that way we can manage the risk of claims and we can give the manager the benefit of the doubt. And I just wonder, it's a bit of a philosophical question really, but should the Weinstein saga and the resulting flood of allegations of harassment in the workplace that we're seeing actually cause us as employment lawyers and as the HR community to rethink the approach, to seek truth first and deal with any resulting consequences thereafter? As I say, it's an interesting philosophical question, and it depends really on what kind of business you want to be working in and what the owners of that business think as well in terms of these things. But certainly a question that we should all be asking ourselves, I think. Now, what about historic allegations? And one way of looking at it is that from a legal perspective, they are low risk because any resulting claims are likely to be out of time. But it is worth thinking about the fact that depending on the seriousness, there could still be a criminal investigation into historic allegation. You could ask yourself the moral question: is there a moral duty on us to investigate as far as we can and reach a decision? Equally, what do we do about the identity of the alleged harasser? Is it appropriate to take disciplinary action if the alleged harasser's still employed, and particularly if this is something that happened a number of years ago? And how reliable is the evidence likely to be? In many cases, and I've seen this happen myself, the easiest thing to do is just make the problem go away and exit the individual under a settlement agreement. But again, query whether that's morally the right thing to do. Are we just potentially moving the problem on? So all of these factors need a bit of thought when we're dealing with historical allegations. And of course, it's all the more difficult if the historic allegation relates to one of your employees now, but involving an incident that happened when they were working for somebody else altogether. And I think my view here is it wouldn't be appropriate in those circumstances to dismiss for any form of misconduct. What we might look at, though, is whether it's reasonable to take action and potentially consider dismissal on the basis of some other substantial reason, perhaps relying on the reasonable belief that there could be a reputational risk to the employer. I would, however, just flag the Employment Appeal Tribunal's findings in that case of A and Z that I've referred to there. Not sexual harassment case as such, but I think the principles carry over. And this was a case involving allegations of historical sex abuse by an individual now working as a school caretaker. Those allegations were under investigation by the police. The school was notified of them. They hadn't at that point been proven, but the individual had been suspended on full pay for some 12 months. And it seems that the school just ran out of patience and said, well, we've got enough here to dismiss because of the reputational risk. And they proceeded to some other substantial reason dismissal. That dismissal was actually held to be unfair, and the EAT said that was the case. I think they were perhaps influenced that by the time of the hearing, so a number of months after the dismissal, the prosecution against the caretaker had been dropped. But I think it's still a useful reminder that some of the substantial reason isn't just a cure-all reason for dismissal. We've got to be clear that there is something substantial that is requiring us to dismiss the individual. Now, I wanted to just focus briefly on whistleblowing, which may seem unusual in the context of allegations about sexual harassment, but it does seem to me that there is a potential issue here that we need to be aware of. And of course, a whistleblower qualifies for protection against dismissal or being subjected to a detriment if they've made a qualifying disclosure and that disclosure is protected. And it seems to me that a complaint of sexual harassment by the victim could potentially be a qualifying disclosure. Either it could be a disclosure relating to a criminal offence, if the harassment involved is that serious, or it could be a disclosure relating to a breach of a legal obligation, duty of mutual trust and confidence, or breach of the employment contract in some other way. But the individual will only be protected if they have a reasonable belief that the alleged failure has happened, and they reasonably believe that the matter is in the public interest. So that begs the question whether complaints of sexual harassment are in the public interest. And there was that Sodexo and Parkins case, which you may well remember, which says that where somebody complains about a breach of their own individual employment contract, that is not, whilst it might be a breach of a legal obligation, it's not a matter of public interest. And sexual harassment allegations will typically just affect one person. So query, is it in the public interest? Now, it certainly could be in the public interest if more than one person has been harassed. And at Chesterton and Nur Mohammed case involving the estate agency that changed its commission structure for senior managers, 100 people affected, alleged breach of contract in the way that they went about doing that, and Nur Mohammed has been given protection as a whistleblower there. But again, that sort of begs the question, where do you draw the line? Okay, it's not one person, but where 100 people are affected, it can be in the public interest. So what happens if it's 2 people? Is that in the public interest? What if it's 5? What if it's 10? And so on. But I would take this a stage further and say, actually, even if it's only one person, it's still arguably a matter of public interest. And the high-profile campaigns such as #MeToo that's prompted this whole webinar are a really good example of the fact that these issues are a matter of public interest. And it seems to me, therefore, that wherever we've got an individual who is alleging harassment, whether or not we conclude that the harassment has happened, we need to be thinking about the fact that they probably or possibly or arguably have whistleblower protection as well, and need to be clear that we are not subjecting them to any form of detriment as a result. I'll just mention briefly Protection from Harassment Act. Remember, this Act, which has both criminal and civil sanctions, prohibits anyone from pursuing a course of conduct which amounts to harassment. Now, under this Act, there has to be 2 or more incidents for there to be that course of conduct. So that's a point of difference from sexual harassment under the Equality Act. And for this conduct to amount to harassment, it must be oppressive and unacceptable, and arguably capable of sustaining criminal liability. And there are decisions going each way on that criminal liability point. But at the moment, the better thinking is that the conduct has to be sufficiently serious to amount to, or to give rise to criminal liability, as well as being oppressive and unacceptable. Important to note that employers can be vicariously liable for the acts of their employees in claims under the Protection from Harassment Act. And of course, a claimant has 6 years to bring the claim. So it's a good option for an individual, particularly where there's a historic allegation. There's no need to identify protected characteristics. So in that sense, it's a lower threshold to get over. And there's no reasonable steps defence that the employer can advance to get themselves off the hook of vicarious liability. So I think this is a route that we may see being used more and more, for particularly, as I say, for the historic claims. So as we come towards the final section of this webinar, let's think about how we do manage a claim if one is presented. So I'm assuming here we've had a claim of sexual harassment, it's gone through early conciliation, and the individual has now proceeded to issue in the employment tribunal. Now, clearly, we will have a number of potential defences that we can run. We might look at the jurisdictional issues, so the alleged incidents could well be out of time. We might look very closely at the definition of harassment and say that what is complained of doesn't amount to harassment in law, or we might argue that we took all reasonable steps to stop the harassment occurring, so that the so-called statutory defence. And we'll look at each of those in a bit more detail. So the out of time point, 3 months from the date of the alleged act, is the time limit for bringing a complaint. But it's important to remember that earlier acts could still be in time if they are part of conduct extending over a period, so the so-called continuing act. For there to be a continuing act, there has to be an ongoing situation or a continuing state of affairs rather than a series of unconnected or isolated incidents. But it doesn't matter if those acts are more than 3 months apart. So they can actually be quite a long time apart where you've got a common personality involved. So we could have a course of conduct or a continuing act going back over a number of years where there have only been sporadic incidents, but where that is the same perpetrator on the same victim, those claims are likely to be in time. Now, if we want to argue that there's no harassment in law, we're going to have to get some pretty compelling evidence together that the conduct didn't happen as the claimant alleges. In most cases, it's going to be one person's word against another, but if we can get witnesses to give statements as well, so much the better. We might well want to argue that if the conduct did occur, it wasn't of a sexual nature. But remember, we've still got the risk of potential sex harassment there. We could certainly argue that the conduct wasn't unwanted, and again, we'd want evidence of the claimant playing along or indeed initiating the conduct. And finally, we would potentially challenge the allegation of harassment on the basis that it's not reasonable for the claimant to feel that her dignity has been violated, or whichever limit is of the definition of harassment she's relying on. In other words, we've got a hypersensitive claimant here. In terms of that statutory defence, obvious point to make, but it has been a point that has been run in tribunal, the steps have to be taken before the harassment occurs. In other words, we can't shut the stable door after the horse has bolted and say that we took reasonable steps in response to a complaint and then did everything exactly as we should do by the book. That won't amount to a statutory defence. So we have to have done something before the harassment occurs, and most people would say that the starting point is that they have some kind of policy that makes it clear that this kind of conduct is unacceptable in the business. But it won't be any surprise to hear me say that the existence of a policy on its own isn't enough. The employer must also have taken reasonable steps to implement that policy. And that means making the employees aware of the policy. It means training managers and supervisors. And I think the point that's often overlooked is it means dealing effectively with complaints, including taking disciplinary action, which reinforces the policy. So if I were looking to be defending an employer and wanting to run that statutory defence, I would absolutely want evidence of what have you done to show that you effectively deal with complaints and have acted, given a deterrent effect in that way. We should also just think about some other issues that may come into play when we're dealing with harassment claims. Possibility of obtaining a restricted reporting order is one to think about. My sense is that we're likely to see an increase in applications for restricted reporting orders, given that tribunal judgments are now published online. So almost in every case, you could ask yourself, is it appropriate to be applying for a restricted reporting order? Something certainly for the company to think about, where one of their employees is named as a respondent and we're backing them in the defence to the claim. But also, tactically, is it something to resist? If the claimant is wanting to make that application, should we be resisting it on the basis that actually that might apply some leverage to encourage the claimant either to withdraw or to settle the claim? Is that a point we want to be making in settlement negotiations that the claimant might not have thought of, that this judgment will be a matter of public record and published online? And in these scenarios, tribunals have a wide discretion and have to balance the requirement for open justice against the individual's right to respect for a private life. So there are always arguments to be made either way, depending which way you want to play it here. I think the final point to think about in terms of managing claims is whether you want to fight or settle. And obviously the usual factors, I think, come into play here when you're looking at that decision. It's clearly, what do the merits look like? Have we got a risk of losing here? But equally, have we got a risk of sending out a message if we settle? What are the management time and costs going to be? And perhaps more importantly than ever in the case of these kind of claims, what sort of adverse PR is going to come along with this sort of claim being heard in a public forum? And my strong recommendation is that we get an early risk assessment and actually agree a litigation strategy when we've got these kind of claims. As part of that strategy, we need to be considering alternative dispute resolution. I'm a big fan of mediation, either judicial mediation or private mediation in sexual harassment cases, particularly where the claimant is still employed and you've got that ongoing working relationship still to manage. If we do get to the point of settlement, then I would be strongly advocating confidentiality clauses, requirement for non-derogatory statements and so on. I think these are still essential. I know that they've come in for a lot of criticism recently in the parliamentary inquiry into the FAA's conduct in the gunnercooke case, but I don't think that should change our stance on these, and that we should be including those as a matter of course in these kind of settlements. Remember that where you've got somebody who suffers harassment as well as injured feelings, they may also have a personal injury, and the tribunal can give compensation for the personal injury that is sustained as part of the remedy. And if that's the case, we might need to be thinking about notifying the employer's liability insurer, because it could well be that element of the award is covered off by insurance, but equally you could well lose that cover if you haven't notified the insurer of the claim in advance. And then final point really, I think, is the importance of just watching out for victimisation claims, and especially that's the case if the claimant remains employed. But even if the claimant doesn't, and we could potentially be victimising them in the way that we respond to a reference request. But if they are still employed, clearly in terms of access to promotion, training opportunities, pay review and bonus time and so on, we need to be absolutely clear with line managers that there can be no less favourable treatment directed at this individual. So I've covered everything there that I wanted to draw out. I'm just going to expand my questions box and see whether we have any questions. I can see that we have a number. Okay, we just actually know that I've just had a look at that. It's just a comment rather than a question, so no need to carry on with that. So unless there are any other questions, I'll just stay online for another 30 seconds. If anyone wants to fire a question, now would be the appropriate time to do it. If we don't cover it on this webinar and you would rather have a word with me direct, then by all means drop me a line or give me a call, or as I said at the beginning, just speak to your usual gunnercooke advisor. Okay, well at that point I'm going to draw this webinar to a close. Thank you for attending. As usual, this will be available to be listened to again on our website, and you can forward the link to that to any colleagues that you think may benefit from it. Thanks all for attending.